Hi, I'm Linda Anderson of Anderson Elder Law, and I just want to take a minute to talk about Medicaid, which is a safety net that serves for long-term care support, and what happens if there have been prior transfers that may result in a transfer penalty. So in order to qualify for Medicaid, you not only have to meet certain income and asset tests as well as medical eligibility. Part of the process of obtaining Medicaid support for payment of nursing home bills or home health care is the idea that they look back 5 years and determine whether or not you've made any gifts that would affect your Medicaid eligibility at the time you're applying. And so there are many myths that people may come to believe to be the absolute truth that time and time again prevent them from actually utilizing the Medicaid for the safety net that it is. One of them is often families will think that I can make gifts of $17,000 per person per year. $17,000 is the 2023 number for annual exclusion gifts, and it gets adjusted every single year. But that has nothing to do with Medicaid. It has to do with our federal estate and gift tax rules. And the idea is that the IRS is trying to keep track of gifting done by people that may be subject to the federal estate or gift tax. Right now, those numbers as who's triggered as a person that needs to worry about it is close to $13 million per person. So it does not actually have a lot of relevance to our clients. And the idea of everybody understanding that $17,000 per person per year is a rule, they're just assuming it has something to do with Medicaid. And in fact, those annual exclusion gifts are not something that are permitted by Medicaid. Pennsylvania has adopted a rule where they'll disregard a total or single gift of $500 a month. But I can't tell you how many people have made gifts of these annual exclusion amounts thinking that that was actually not going to be a problem. The other thing that's interesting is that many times people will have made gifts, perhaps paid for a wedding or helped grandchildren with an education or done other kinds of gifting, and have all of a sudden an unexpected Medicaid situation. And what they didn't realize is that it's not that any gift will disqualify you for 5 years, it's that the look-back period is 5 years. And when that application is submitted, it discloses every single gift, and you have an opportunity to explain why the gift was made. And so one example of a gift that will not have a transfer penalty is perhaps there was a gift that was made prior to a stroke, and then after the stroke, the person applied for Medicaid. And when you disclose that you were perfectly healthy at the time of the gift, you're able to say it was exclusively other than to qualify for Medicaid. And that is what is federal law as a protected gift and should not actually result in a transfer penalty. There are some gifts that will actually result in a transfer penalty, and what you need to know is that by early planning, we may be able to actually soften the impact of those gifts. And if we're not softening them, that we're actually trying to negotiate a way out of them to make sure that we don't have any filial responsibility claims against adult children. Don't be afraid to get information if you've made gifts, and don't be afraid to actually proceed with careful Medicaid planning. If you do gifts, the job of the elder law attorney is to make sure that there's a path going forward that will cover any transfer penalty. If you need more information, please check out our website or feel free to call our office.